Okay, let's unpack this. We're doing a deep dive today into a really critical area, criminal defense.
Hmm.
And we're drawing specifically from insights provided by the law offices of Haskell and Dyer, their attorneys practicing down in Southern Maryland.
That's right. So our source material here, it's basically information from Jonathan Haskell and Matthew Dyer themselves, giving us a window into how they operate.
Right, across Anne Arundel, Calvert, Charles, St. Mary's, and Prince George's counties.
Exactly, those areas.
And our goal, our mission for this dive, is pretty straightforward, really. We want to get a handle on their criminal defense work based on what they've shared.
Yeah, like what kinds of cases are typical in that region for them?
And how do they approach building a defense? What's their role fundamentally? Especially, if you're facing charges there, it can be incredibly confusing.
Oh, definitely. And the sources, they actually touch on that right away, that feeling of confusion, all the questions, the pressure you're under when accused.
They acknowledge it directly.
Yeah, and they sort of position the defense attorney as your guide, your advocate through that whole often overwhelming process.
Okay, so let's start with the range, the scope of cases.
Yeah.
The information we have suggests it's really broad.
Absolutely. It's not just one niche area. The material makes it clear they handle a vast spectrum of criminal charges.
Like what specifically?
Well, it runs the gamut. Everything from, say, motor vehicle offenses, DUI, other traffic stuff, right up to the most serious charges you can imagine.
Like violent crimes, murder.
Exactly. Violent crimes, murder, homicide, sex crimes. They cover those according to the sources.
Wow, and it doesn't stop there, right? They also mention things like drug crimes, white-collar stuff.
Drug crimes, white-collar crime, weapons charges are in there, juvenile cases too, and theft or robbery.
So it really seems like the message is, if you're facing pretty much any criminal charge in the Southern Maryland counties, the sources indicate they handle it.
That's the picture painted, yeah. Felonies, misdemeanors, gun charges, fraud, DUI, drugs, even traffic tickets. Seems like they're equipped across the board for that specific region.
Okay, so that covers the what. Now, maybe the more interesting part for me is the how. How do they actually approach defending someone? The sources talk about a particular strategy.
They do. They describe it as a proactive approach, which means, not just sitting back and reacting.
So being aggressive from the start.
Kind of.
Yeah.
It involved actively investigating, preparing challenges right away. They talk about meticulously examining every single element of the government's case against you.
Okay, meticulously examining every element. That sounds intense. For someone listening who isn't a lawyer, what does that actually look like in practice based on these materials?
Well, it means digging into everything. Every piece of evidence the prosecution plans to use. Police reports, how they were written.
Witness statement.
Witness statements, definitely. But also, how was the evidence itself collected? Was the chain of custody okay? If there's forensic analysis, scrutinizing that too.
And witnesses.
Oh yeah, cross-examining witnesses is huge. Not just accepting their story, but actively testing it. Looking for, holes, inconsistencies, maybe challenging if they're really credible. The whole point, as the sources emphasize, is working to establish reasonable doubt.
Ah, okay. The big one. Beyond a reasonable doubt. That cornerstone of criminal law, the prosecution has to meet that standard.
Precisely. And the sources really hammer this home. The government, the state, carries that incredibly high burden. They must prove their case beyond a reasonable doubt before you can be convicted.
So the defense strategy, a core part of it anyway, is basically attacking the prosecution's case to show they haven't met that very high bar.
Yes, exactly.
Yeah.
It's about challenging if they can truly, legally meet that stringent standard. And if they think the state falls short, the sources say they push hard for dismissal.
So one major goal is find the weaknesses, show the doubt, and potentially get the case thrown out.
That's definitely one key objective described, trying to dismantle the state's case to show that proof standard just isn't met.
But the sources also mention another really critical role for the defense attorney, right? One that isn't always about, strictly speaking, proving innocence.
Yes, and this is really important. The material acknowledges that sometimes, just fighting about reasonable doubt isn't the only path. Maybe it's not even the most strategic one, especially if, say, a plea bargain is being discussed.
Right.
In those cases, the focus kind of shifts. It becomes about minimizing the negative consequences.
Minimizing negative effects.
Yeah.
Okay, for someone facing charges, what does that mean practically? What are those effects, and how does the attorney try to lessen them?
Well, it's fundamentally about protecting your future. Trying to avoid or shorten prison time is obviously a big one.
Sure.
But also protecting things like professional licenses, maybe keeping your criminal record as clean as possible, avoiding other sort of collateral consequences that can follow you for years.
So if a plea deal is possible, the attorneys then negotiate hard.
That's what the sources indicate. They diligently negotiate, constantly pushing for things like alternate sentences, maybe probation instead of jail, or perhaps getting the charges reduced to something less serious.
And the aim there?
The aim is always to help the client avoid the worst outcomes, the most severe penalties. The sources actually state their role is protecting your rights and interests no matter the circumstances.
Okay.
Which suggests that this negotiation part is just as vital as, picking apart evidence in court.
Gotcha. So it sounds like the sources describe a kind of two-pronged approach. First, you rigorously challenge the state's case, aiming for dismissal based on that reasonable doubt standard. But if that's not feasible, or maybe not the best path, you pivot to aggressive negotiation to minimize the damage and secure the best possible outcome for the client's life moving forward.
That sums it up nicely, yeah.
Yeah.
Advocating for the client's best interest at every single stage, whether that means fighting the charges tooth and nail or working strategically through negotiation to build a better path forward.
And it's worth repeating, right? All these insights, these approaches, challenging the standard, negotiating outcomes are presented from this specific viewpoint of Haskell and Dyer, attorneys practicing criminal defense in those particular southern Maryland counties.
Exactly. Anne Arundel, Calvert, Charles, St. Mary's, and Prince George's. The information reflects their experience within that specific legal environment.
So thinking about the listener, why is knowing all this important, especially if you're in that area?
Well, I think it means understanding that the system has complexities. You need to recognize that really high bar the prosecution faces beyond a reasonable doubt.
Right.
And that a defense attorney's job, as described here, involves a proactive strategy to see if the state can even meet it. But crucially, it also shows their role doesn't just stop there.
It extends to that negotiation piece.
Yeah, advocating for your future, minimizing those potential lifelong impacts through skilled negotiation. It highlights that even if an outright dismissal isn't in the cards, there's still critical work to be done.
So, knowing about both challenging the legal standard and the art of negotiation gives you, the person potentially needing help, really essential context for what a defense attorney can do in those specific counties. It shows the different ways they can add value.
Absolutely. It offers a clearer picture of the potential strategies and the kind of dedicated advocacy the sources suggest these particular attorneys provide in Southern Maryland.
Okay, so based just on what we've unpacked from these sources, here's something for you to think about, that phrase, beyond a reasonable doubt. We talked about how defense attorneys scrutinize evidence to challenge it. How does that process itself, digging into every police report detail, every witness inconsistency, how does that directly work to introduce that specific kind of doubt in a judge or jury's mind? And then maybe contrast that. How might the attorney's actual skill set, their focus, maybe even their demeanor, differ when they're in that mode fighting hard for dismissal versus when they're deeply involved in negotiating the best possible plea or sentence to safeguard your future?